Welcome to the Supreme Court of the United Kingdom, where we're beginning the second day of the hearing of the appeal in the case of Begum and the Home Secretary. We're hearing submissions at the moment by counsel appearing on behalf of Ms. Begum. That's Lord Panic, and I'll turn now to him. Lord Panic.
Thank you very much, my Lord. Good morning, my Lords. Good morning, my lady. The President invited our attention yesterday afternoon to the decision of the Appellate Committee in the Riemann case. That case has since been considered by SIAC in a number of authorities, and to summarise the position as we see it, the SIAC decisions recognise that the speeches in Riemann, not just Lord Hoffman, but there was a wide variety of speeches, support a distinction between questions of fact which need to be proved by the Secretary of State to a civil standard, and more general questions of judgment as to the level of risk going forward which is posed by the individual. And in respect of that latter issue, SIAC gives more substantial weight to the views of the Secretary of State. Although, of course, if the judgment of the Secretary of State on risk is informed by alleged facts which are not found to be proved, then the judgment of the Secretary of State may carry less force. It's all going to depend, as Lord Hoffman himself said in his speech, on the particular circumstances of the particular case. This court has a number of SIAC decisions. It has Al Jeddah at EF 1639 in SIAC, paragraph 9. That's 2009, the year 2009. It has the decision we sent in this morning, Zatu Liveta. That's a SIAC decision in 2011, paragraphs 4 through to 8. Fascinating.
Just to interrupt you before we go through them all, the first one you mentioned is rather startling, paragraph 9 of Al Jeddah. Is having recited what Lord Hoffman said, and that Lord Clyde and Lord Hutton had agreed, the tribunal say, we do not accept this limitation upon our decision-making powers.
I did notice that, my Lord, yes.
Yeah.
It's not an approach to adjudication at that level that I would respectfully commend to this court, but the other decisions adopt what may be thought to be the more traditional approach of seeking to identify what was actually decided and what the majority was. And they explain in the terms that I've sought to summarise what the position actually was. The second of them I'd mentioned is Zatu Liveta, which is a 2011 decision at paragraphs 4 to 8. I won't take the court to it, but it is a fascinating case in which SIAC concluded that the appellant was not a Russian spy. The SIAC panel, including the former head of MI5. There's also Y1, which is at EF 3047, paragraphs 13 and 56. That's a decision in 2013 by Mr. Justice Irwin as the then president of the tribunal. And more recently, after Lord Wilson's analysis in Al Jeddah at EF 1717, there's the more recent case D2, which Mr. Glasson sent in helpfully this morning, and that's Mrs. Justice Lang as the president of SIAC. Her judgment does not refer to any of the previous cases, other than Raymond, of course. So there it is. we say that the hearing before SIAC is different from a conventional appeal because in a conventional appeal, the decision maker at first instance will have heard from both sides in the normal course of events. That's not so in the present context. The appellant in the deprivation appeal will not have had any opportunity to present evidence or argument before the decision is taken. And indeed, that was the complaint in Al-Jeddah number 2, which is EF 1652 at paragraphs 155 to 159. And what SIAC held in Al-Jeddah number 2 was, and that was a decision of Mr. Justice Flo, as he then was, because he was the president of SIAC in 2016. He held that the Secretary of State has no duty to give prior notice of a deprivation decision. And Mr. Justice Flo emphasised that a substantial reason for that conclusion was that Parliament has provided a right of appeal on the merits. And as a matter of practice, the Secretary of State does not give prior notice. So SIAC is hearing evidence and making findings on material not considered by the Secretary of State. Now, I'm not inviting this court to decide this question of how intensive an appeal before SIAC should be. And the reason I'm not inviting this court to decide that matter is because it doesn't alter the fact that Parliament has conferred a right of appeal to an independent tribunal before which the Secretary of State, to whatever standard, must justify her decision. And that is an important control on the discretion of the Secretary of State. And Parliament did not confer this right of appeal only because Ms. Begum might be able to persuade SIAC to allow the appeal. Procedural fairness has other functions, very important functions, which my Lord the President spelt out for the court in the Osborne case, EF 2445 at paragraphs 67 to 71, a judgment which was applied and indeed developed in the recent joint judgment of my lady, Lady Black, with Lord Kerr, with Lord Wilson agreeing, in the Parthon case. It's reported in 2020, One Weekly Law Reports 4506. And this is very familiar territory for this court. But what, if I may summarise, what my Lord the President said is that procedural fairness is important also to ensure that the subject of the decision is satisfied that she has been heard. And I would add not just the appellant, but the section of the wider community from which she comes. And also, my Lord said, and we respectfully agree, a function of procedural fairness is to uphold the rule of law. It's to ensure that when the Secretary of State makes as important a decision as this one, she is applying proper standards. She's making a decision which can stand up to scrutiny. And all of that is of vital importance in this sensitive context. And that's why we're making the submission, which I developed yesterday, that the requirements of procedural fairness cannot, in our respectful submission, be overridden by national security without express statutory authority. So that's what I want to say on Raymond, my lords, my lady. Can I turn to the next topic, which is why SIAC concluded that Ms. Begum would be unable to enjoy a meaningful right of appeal in the circumstances of this case. And I'd referred to the open and closed parts of the witness statement of my instructing solicitor, Mr. Ferner from Bernburg Pierce. The open version, if I can take the court to that, can be found at EF 1440. And the relevant passage that your lordships may wish to look at, first of all, is at EF 1444, paragraphs 24 and 25, where Mr. Ferner points out that he's been told that no legal representatives or NGOs concerned in the initiation of legal proceedings are allowed into the camp. And at 25, they don't permit detainees to hold or use mobile phones. Serious penalties are imposed on those caught communicating on unauthorized phones. Their people are placed in isolation, they're separated from their children. On occasion, they are beaten. And over the page, Mr. Ferner deals with the limited public phone service that is offered, but it's not available for contact with lawyers, and there's no facility to make or receive calls, it's messages. And Mr. Ferner then explains at 29 and 30 why he hasn't tried to attend, not least because it's impossible to get in. If the court turns back earlier in this statement at 1440, your lordships will see that at paragraph 4, Mr. Ferner summarises his extensive experience, and it is extensive, of conducting proceedings before SIAC of this nature. At paragraph 7 through to 11, I won't read it all out. I hope the court, I'm sure the court has read it. Paragraph 7 to 11 at EF 1441, he describes the complexity and the intensity of the process which is required in order to obtain instructions from the client, both on the case against her and on any mitigating or exonerating material that she wishes to present. Of course, the representation doesn't end at that stage. He's then going to need further instructions from her on any further evidence that is then disclosed by the Secretary of State in response to her material. Mr. Ferner is going to need her instructions on any points, new points, different points raised in the skeleton argument for the Secretary of State for the hearing. And he's going to need to communicate with her to discuss any points raised in argument at the hearing, whether by counsel or indeed by members of SIAC. And those additional matters are mentioned in a further confidential statement, which I don't ask the court to turn up, but can I give the court the reference? It's EF 4703 at paragraphs 21 and 22. Mr. Ferner has also addressed in detail in his confidential evidence how he has obtained instructions under the current constraints relating to the issues that are raised in these preliminary proceedings. And that confidential evidence, again, I don't ask the court to turn it up, but can I give the reference? The confidential evidence is at EF 398 at paragraphs 18 through to 23. and 26 to 27. That's EF 398. Paragraphs 18 to 23, 26 to 27. Those are the paragraphs which are excised from the open statement at EF 1443 through to 1445. There's a further confidential statement by Mr. Ferner which adds a point of detail, and again I give the reference. It's EF 406 at paragraph 7. There's also a third open statement which I do ask the court to look at, which is at EF 499. That's dated the 21st of October 2019. This was before, this is all this material before the SIAC hearing. And at 499, at paragraphs 15 through to 19, Mr. Ferner addresses the fact that he has obtained instructions to address the matters that are raised in these preliminary proceedings, 15 to 19. As he says, those issues do not require detailed instructions, particularly on the substance of the national security case, and he explains that vital distinction between, on the one hand, the respondent being able, Miss Begum being able to provide limited instructions to enable her lawyers to advance the procedural arguments, and on the other hand, her being unable to communicate to him a detailed factual response to the substantive issues raised by the Secretary of State and to present her account of events. There's also, just to complete the evidence, there was also before SIAC a confidential statement from witness B, both her identity and her evidence being confidential. So can I simply direct, please, the court's attention to that document? It's at EF 520 and at paragraphs 20 through to 34, she explains the difficulties of access to the camp, and she points out, and I mentioned this because Sir James drew particular attention to the fact that Miss Begum was seen by journalists in the camp. That witness specifically explains at paragraph 21, which is on EF 525, that journalists, as opposed to lawyers, are allowed into the camp. Now, the position is that the Secretary of State did not challenge any of this evidence by way of cross-examination before SIAC, and indeed the Secretary of State presented no evidence to the contrary on these questions of Mr. Ferner's ability to take meaningful instructions from Miss Begum on the substantive issue. The impediments to Miss Begum having a fair and effective opportunity to present her appeal are not peripheral to the appeal. They are absolutely central to her ability to have a meaningful opportunity to appeal, particularly where the presence of her explanations, her mitigations, for alleged past actions and her evidence on her present attitudes are likely to be, at the very least, significant elements of any appeal. Sir James then submitted that it assists the Secretary of State that by reason of an amendment to section 40 capital A made in 2004, it was made by the Asylum and Immigration Treatment of Claimants Act, Parliament has removed the previous prohibition in section 40 capital A6 on a deprivation order being made prior to an appeal being concluded. And I just show the court the provision so the court understands the points that I'm dealing with. It's in the separate document dealing with supplemental materials, which has its own numbering. Yes, it's page 99 of the separate EF file, if the court has that. Of course, I've got it in a bundle, Supplemental Materials Volume 2, and it's a separate EF numbering, and it's numbering page 99. I'm grateful. And the court will see that the earlier version of section 40 capital A included section 40 capital A subsection 6. And that provided that an order under section 40, that's the deprivation order, may not be made in respect of a person while an appeal under this section or section 2B of the SIAC Act has been instituted and has not yet been finally determined, withdrawn or abandoned, or could be brought, leaving aside proceedings out of time. So that was the position until that provision was removed by the Asylum and Immigration (brackets) Treatment of Claimants (close brackets) Act 2004. And SIAC held, I won't take the court to it, but I'll give the reference. SIAC held at paragraphs 151 and 152, it's EF 350, that this was a point in favour of the Secretary of State. And my response, with respect, is that it's a bad point. And it's a bad point because the fact that Parliament allowed for appeals to be held from outside the United Kingdom does not mean that Parliament intended that appellants would not be entitled to a fair, effective, meaningful appeal from outside the United Kingdom. Indeed, my lords, my lady, to the contrary, the fact that Parliament allowed deprivation decisions to be taken and implemented before appeals were heard demonstrated confidence by Parliament that appeals from abroad would be fair and effective. And indeed, that was a point made by the government itself when further changes were made to deprivation of citizenship powers in 2014, allowing a naturalised citizen to be rendered stateless by a deprivation order. And we've set out the minister's statement in our written case at footnote 19 which is on EF 169. I won't take time on it, but that's what the Minister said, that the fact that an appeal is heard abroad doesn't mean that it's not an effective appeal. Of course, we accept that Parliament envisaged that an appeal from abroad may encounter greater difficulty than an appeal from within the United Kingdom. It is inherently more difficult to appeal from abroad than it is from within the United Kingdom. You won't have, with ease, face-to-face contact with your legal representative. But there is a difference, my lords, my lady, a fundamental difference between difficulties in appealing from abroad and a situation such as this, exceptionally in this appeal, where there is a finding that a person simply does not have an effective, a meaningful opportunity to appeal from abroad. That is the situation in this case. We're not arguing about difficulties, about inadequacies. We're arguing about a fundamental inability to conduct a meaningful appeal for the reasons that Mr. Furner has explained. If it matters, we also point out that the reason why Parliament made this change to allow deprivation decisions to be made before appeals were heard was to enable deportation orders to be made against individuals and for appeals to be heard at the same time relating to deportation appeals and deprivation appeals. We see that in the explanatory note when the legislation was changed. It's EF 1490. So for those reasons, we respectfully dispute that amendment allowing decisions to be made with appeals from abroad assists the court in relation to the issues before it today. Can I turn to national security, on which Sir James founds his appeal? I made the submission yesterday, and I won't repeat it because your lordships, your ladyship have it, that there is in our submission no basis to imply into the statutory scheme a limitation, an exception to procedural fairness where the interests of national security so require, not least where Parliament itself has legislated in a context concerned with national security, and when Parliament has provided for limitations on procedural fairness by reason of national security, that is in relation to disclosure of information, as it sees fit. If, contrary to that submission, national security is relevant to this appeal, then we say that the Court of Appeal adopted the correct approach at paragraphs 119 to 121 of the judgment, which the court has read and indeed was taken to yesterday. In relation to the substance of the criticisms which my friend Sir James made yesterday, his case is that very serious national security risks arise out of the basic facts that Ms. Begum travelled to Syria and aligned herself with ISIL. Our response is as follows. The first point we wish to make is that it cannot be assumed, and indeed it will be an issue on any appeal, that because Miss Begum travelled to Syria and because there is evidence that she aligned herself with ISIL, it therefore follows that she constitutes a continuing threat, or indeed what degree of threat she will pose on her return. And in that respect, may I invite the court's attention to the Home Office document, which appears at EF 727. This is a document entitled Foreign Terrorist Travellers, Core Script and Questions and Answers, and it's dated April 2019, as the court sees. And if the court please would turn to page 729, EF 729, the court will see that under the heading at the top of the page, top lines on foreign terrorist travellers, the first subheading is the scale and nature of the threat. And we're then told the following. Around 900 people have travelled from the United Kingdom to engage with the conflict in Syria and Iraq against the advice of the Foreign Office. Of these, approximately 20% have been killed in the conflict, and around 40% have returned to the United Kingdom. That's as at April 2019, about 400 people. Inevitably, many more in the 18 months that have followed. And in this, they have all been investigated, and the majority have been assessed to pose no or a low security risk. It then goes on. Those who remain in the conflict zone include some of the most dangerous, choosing to stay to fight, raise families, or otherwise support Daesh. They turned their back on this country to support a group that butchered and beheaded innocent civilians, including British citizens. These individuals pose a greater threat to the UK than individuals who returned earlier in the conflict. They will have received combat training, intense indoctrination, and will have had the opportunity to expand their terrorist network. Now, I draw attention to that because it demonstrates in my submission that it is necessary to assess the particular circumstances of the individual case. And although the second sub-paragraph does make statements relating to the greater danger posed by those who have been there the longest, the first paragraph does recognise that it is not the case that everyone who has travelled to Syria and aligned with ISIL pose any security risk or any substantial security risk. In my submission, what degree of threat, if any, Ms. Begum will pose on her return inevitably depends on the circumstances of her case. It's going to depend on the circumstances in which she travelled there, the circumstances in which she remained there, and an assessment of her, of the risk, if any, that she, as an individual, poses on her return. Sir James, with all due respect to him, is asking the court to assume the worst when the purpose of the appeal is to examine and to determine the facts. I mentioned yesterday, this is still the first point, I mentioned yesterday, my lords, my lady, that SIAC may be asked on the substantive appeal to have regard in particular to the circumstances in which Ms. Begum left this country in 2015. That issue has been raised in our grounds of appeal to SIAC. I just give the reference, it's EF 601 bullet point E, which refers to the apparent failure of any safeguarding mechanisms in relation to a 15-year-old girl. I should also mention that Sir James took the court to Miss Begum's interview in the Times. Sir James was making a point about how Miss Begum, even in February 2019, appeared still to be aligned with ISIL. I draw the court's attention to the fact that there's a later interview in which Miss Begum told the journalist, it's a Mail journalist, Daily Mail journalist, she made the comments, she says she made the earlier comments to protect herself from violence from supporters of ISIL in the camp. That appears at EF 1205 at the bottom of the page to the top of EF 1206. Yes, thank you. To protect her and her child. Of course, I'm not asking this court to determine these matters in this appeal. They are matters for the substantive appeal. But again, I'm concerned on behalf of Miss Begum that the court understands the explanation that she would be giving in any substantive appeal. So that's the first point I want to make on national security. The second point I want to make on national security is that the court does have in the core volume, and the court has seen it, the security assessment that has been made in relation to this case. And it's at EF 369 and following. And it is striking in our submission that the document that went to the Secretary of State, then, as I've said, Mr. Sajid Javid, the document that went to the Minister, the Secretary of State, did not advise him that the risk posed by Miss Begum, were she to return to this country for her appeal, would be unmanageable. That was not the advice. Can I draw attention to what the advice was? It's at EF 370. Sir James has read out much of this, but not, I think, the passage on which we rely. Sir James drew attention to, on page 370, to paragraph D at the top and paragraph E. Paragraph H, I've already drawn attention to the advice to the Secretary of State that should Miss Begum become aware of the deprivation decision while she's in the camp, that's the first camp, it's difficult to see how she might effectively exercise her appeal right from that location. And then this, however, SCU, Serious Cases Unit's position is that where she has been out of the UK for several years through her own choice, we would argue that it would be incorrect to allow her to return to the UK to engage with her appeal. And then they deal with whether she could travel in any event, which is a point I'll come back to. So that's the advice, that it would be incorrect to allow her to return. Now, my submission is that if it were the position of the Special Cases Unit that the return of Miss Begum to engage with her appeal would pose an unmanageable risk to national security, that is, that TPIMs or any other administrative measure would be inadequate, one would have expected the advice to the Home Secretary to have said so. And it does not say so. Indeed, it is striking that the document does not address whether the threat that Miss Begum was perceived to pose could be addressed through TPIMs or other administrative measures. There's no analysis of that question. Sir James made a powerful submission on that point, but it isn't actually the conclusion in the advice to the Special Cases Unit. That's my second point. My third point, in response to Sir James, is that he suggested that TPIMs and indeed prosecution would not be suitable, effective means of protecting national security against the threats posed, perceived to be posed, by those who return from alignment with ISIL in Syria. In our submission, that approach is contrary to the reality of what is happening in the vast majority of the cases in which people who are British citizens do return to this country after travelling to Syria and aligning with ISIL, because the legal reality is that it is only in a narrow category of cases, of which Miss Begum is said to be one, that the Secretary of State is able lawfully to deprive such a person of his or her British citizenship. The court has seen the statutory provisions, and in relation to a person who has citizenship other than by registration or naturalization, the Secretary of State has no power, no power to deprive the British citizen of her citizenship unless the Secretary of State is able to say that the individual has or is capable of acquiring the citizenship of another country. And that's a narrow category. It's also a very arbitrary category, but it's a very narrow category. And of course, if Miss Begum had parents who did not derive from another country, such as Bangladesh, and if that other country had different citizenship rules on the findings, the Secretary of State would not be able to take her citizenship away. So my point is that other than in this exceptional category of cases, the Secretary of State does depend on TPIMs and on prosecution to protect this country from British citizens who return from abroad after aligning with ISIL. And we've seen, I've shown the court the reference in the Home Office document, that there is a substantial number of such people who do return to this country. So I say that the Court of Appeal was correct in assessing the national security arguments presented by the Secretary of State, arguments presented without any factual basis in the advice to the minister about the inadequacies of the alleged inadequacies of TPIMs. The Court of Appeal, in any event, was entitled to take into account the mechanisms which have been approved by Parliament. I mean, these are not administrative measures. Parliament has carefully addressed and assessed and approved a series of administrative measures, including TPIMs, including asset freezing, to address the national security problems which arise in relation to people in this country who pose a threat or are perceived to pose a threat to national security. Sir James also said that there's no evidence that police investigations or prosecutions play any role in this context. Sir James suggested this is a purely theoretical argument. Well, with respect, that's not right. If your lordships, your ladyship would go to EF 727, it's the same document I showed the court a few moments ago, EF 727, which is the Foreign Terrorist Travellers Core Script Questions and Answers document. I'd shown the court a few moments ago, page 729. Could I also please invite the court's attention to page EF 737, and at the bottom of the page there's a heading Prosecutions, page 737. Prosecutions, and the question is, what have you done with those who have come back? Not many prosecutions, question mark. And the answer from the Home Office is this: there are a range of tough measures to deal with people who pose a serious threat to the UK. As of June 2018, so that's 2.5 years ago, there had been around 40 convictions of individuals who had been prosecuted following their return from Syria for a range of offences, either connected to their activities overseas or subsequent counter-terrorism investigations. And then it gives examples, and it does say, I accept, in the second paragraph on page 738, the majority of those who have returned did so in the early stages of the conflict and have been investigated. A significant proportion of these individuals are assessed as no longer being of national security concern. But one can infer from that that those who were prosecuted must have come from the cohort of those who came back later and who were assessed as posing at least some national security concern. And then there's a heading: what kind of offences could returners be charged with? What kind of sentences will they face? And then we're told, even before the recent extensions of extraterritorial jurisdiction that's in the Counter-Terrorism and Border Security Act, the courts already could try cases involving overseas terrorism offences relevant to foreign fighters. And the offences include preparation of terrorism, maximum sentence life imprisonment, encouragement of terrorism, maximum sentence extended from 7 to 15 years, training for terrorism, maximum sentence life imprisonment, and membership of a proscribed organisation, maximum sentence 10 years. Then we're told that the Counter-Terrorism and Border Security Act extended, says we, I think they mean Parliament, extended extraterritorial jurisdiction to the offences of inviting or expressing support for a proscribed organisation, maximum sentence 10 years, displaying an article associated with a prescribed organisation 6 months, dissemination of terrorist publications 7 to 15 years, making or possessing explosives, life imprisonment. These are very serious criminal offences which are available to be used where appropriate in relation to those who return from abroad. And I, with respect, do not accept Sir James's suggestion that none of this is relevant to the ability of our security services to protect the United Kingdom from those who return from Syria, having aligned themselves with ISIL. Those are very powerful criminal penalties, and if Parliament thinks that they are inadequate, then Parliament can amend them as it sees fit, and the Home Secretary can, of course, invite Parliament to amend them as Parliament sees fit. So I do submit that for those reasons that the court cannot assume, should not assume, that Miss Begum will be in the category of those who pose the most serious threats on her return. That's not the and that TPIMs and criminal prosecutions are inadequate to protect this country from her when she returns. And indeed, that's not what the security assessment told the Home Secretary. That's what the Home Office rely upon in the vast majority of cases, and there's every reason why Miss Begum's effective right to a meaningful appeal should be facilitated by her return, with those measures being utilised to such extent as the security services think appropriate, in her case as in others. Sir James relied on the judgment of the Court of Appeal in the XH case. I won't ask the court to go back to it, but it was EF 2994, where the Court of Appeal held that the power to impose a TPIM on a person in this country does not remove the prerogative power to refuse to issue or to cancel a passport for a person abroad. But that doesn't resolve, in my submission, the distinct issue in this case. The distinct issue arising out of the statutory right of appeal, which Miss Begum enjoys to appeal against her deprivation decision. And to the extent that there's any balancing exercise to be conducted, the Court of Appeal was correct, in my submission, to have regard to the availability of TPIMs and indeed criminal prosecutions to address the national security concerns which Sir James has emphasised, particularly in a case, as I've said, where the security advice to the Home Secretary does not advise him that those measures are inadequate to address the risk that Ms. Begum poses. The Secretary of State has also suggested to the court in her written case that the Court of Appeal lacked important information in order to make a proper assessment of national security considerations. Can I just show the court what the Secretary of State says in her written case? It's at EF 138, and it's paragraphs 53 and 54. If I could if I could show the court that, please. EF 138, paragraph 53, where it's said on behalf of the Secretary of State, the only material which the Court of Appeal had before it was the open Begum specific assessment annexed to the ministerial submission, and a reference in that submission to the open ISIL threat statement. The court thus did not even have before it the full open national security case at this stage. It did not examine any of the closed material, and it refused to admit SIAC's closed judgment into the appeal proceedings. It did not have before it, as the Court of Appeal, the full unredacted version of the security service assessment that was appended to the ministerial submission. And then 54, in those circumstances, it is submitted that the Court of Appeal had no proper basis for the findings it sought to make as to the nature and weight of the national security risk posed by Ms. Begum on return. It weighed the national security case against Ms. Begum's procedural interests without knowing what the national security case actually was. That's the contention. Now, the special advocates have produced a helpful note for the court which addresses these complaints. And the court will find the note from the special advocates at page EF 4756. Of course, the special advocates have seen all the closed material, which, of course, we have not. And what they say at paragraph 6, which is on EF 4757, and they're addressing the paragraphs I've just read out in the Secretary of State's case. What they say at paragraph 6 is that the Secretary of State's submission carries the suggestion that the closed material and/or closed judgment was capable of influencing the Court of Appeal's decision in relation to the remedy, that is, the requirement of the grant of leave to enter, it granted. Effectively, the Secretary of State is conjuring the spectre of a national security case behind the closed veil, a case that is significantly different or weightier than that which is available in open. As set out below, the special advocates submit that is not justifiable, either as a matter of principle or fact, and that this is apparent from what has been stated in open. And they then comment on the three areas which the Secretary of State complains that the Court of Appeal did not see. The first of the three matters that the Secretary of State complains the Court of Appeal did not see was the closed judgment of SIAC. And the special advocates address this point at paragraph 7 of their note on the next page, 4758. And they say this: the short closed judgment produced by SIAC was concerned with Article 2.3 risks faced by Ms. Begum. That has been expressly stated in the Secretary of State's own case at paragraph 70. This is the Special Advocate's judgment, it was of no relevance to the Secretary of State's case on national security, nor any other national security considerations. The assertion in the Secretary of State's case that the Court of Appeal was disabled from reaching the conclusion it did through having declined to view the closed judgment is not sustainable. That's what they say. The Secretary of State has filed a note responding to this note from the special advocates, and the court will find the Secretary of State's note in the new bundle, the new supplementary bundle, which is at separate numbering EF26. And the Secretary of State deals with her complaints about the Court of Appeal not looking at the closed judgment on page EF28 at paragraph 5. And at paragraph 5, the Secretary of State says this on page 28. The Secretary of State made clear in her written case that SIAC's closed judgment was concerned with Article 2.3 risks. See written case, paragraph 70. And that's right. The special advocates acknowledge that fact, but they do not explain against that background on what basis they are able or entitled to object to the Secretary of State's references to the closed judgment. The reference at paragraph 70 is specifically made in relation to the Article 2.3 practice issue, to which the closed judgment was plainly relevant. The only other reference to the closed judgment is in paragraph 53 of the written case, where it is stated as a matter of fact that the Court of Appeal refused to admit closed judgment into evidence. Well, with great respect, that really doesn't meet the point, because the point made by the special advocates is that you, the Secretary of State, are telling this court that the Court of Appeal was impeded by not having access to the closed judgment, when we, the special advocates, know that the closed judgment had no relevance, that's what the special advocates say, no relevance to national security issues. And it's that which paragraph 5 of the Secretary of State's response simply doesn't address. So that part of the complaint is a complete red herring in my respectful submission. The second part of the Secretary of State's complaint is that the Court of Appeal did not have access to the closed material. That's at the second point made in paragraph 53 of the Secretary of State's written case. And this point is addressed by the special advocates in their note 4758 at paragraph 8. And this is what the special advocates tell the court. It is correct, as the Secretary of State states, that there was closed material relevant to the Secretary of State's case on national security that was available to SIAC. However, it has been confirmed by the Secretary of State that the national security case, for the purposes of the preliminary issues, was the same as that which was available in open. See footnote 2 to the Security Service assessment, Annex A to the submission. And they've given a reference, but that's the old reference. It's not the EF reference. The EF reference, which I invite the court to turn up, please, is EF 372. This is the submission to yes, it's the Security Service Assessment. I'm sorry, it's Annex A to the submission to the Home Secretary. It's EF 372, and the court sees about 8 lines down, there's a heading summary, and the summary relates to the circumstances. Key assessment. I'm sorry, I should look at key assessment. The first heading, key assessment. The Security Service assesses that Ms. Begum travelled to Syria and aligned with ISIL, which is the basis of the national security case. And footnote 2, to which the special advocates have drawn attention, says this: for the purpose of the SIAC deprivation appeal, and at this stage in the proceedings, that's dealing with these preliminary issues, this assessment is the only assessment relied upon in both the open and closed case. In other words, this is their case for the purpose of the preliminary issues. The special...
Look, Panic, if I can just interrupt for a moment. The question whether she should be granted leave to enter, as the Court of Appeal ordered, wasn't one of the preliminary issues.
No, but the preliminary...
it wasn't an issue in the SIAC deprivation appeal at all. It was raised in the argument in that appeal was that because she couldn't have a fair and effective hearing from outside the UK and in Syria, her appeal should therefore be granted. The argument that she should be, as an alternative, that she should be granted leave to enter was raised in the JR proceedings.
Well, it was raised in both because the open judgment of SIAC dealt with the various possibilities, the ways in which her appeal could be made meaningful, or what consequences flowed from there being no meaningful appeal at paragraph 191. And of course it was open to the Secretary of State to adopt a different approach at the hearing.
Yes, all I'm focusing on, Lord Panic, is insofar as you're relying on the Secretary of State accepting that, so far as the preliminary issues in the deprivation appeal were concerned, the closed material didn't add anything that was being relied on. Well, those issues didn't include the one that the Court of Appeal was dealing with when it decided to grant leave to enter.
Yeah. Well, can I deal with it in this way, my lord? Even assuming that point is a good point.
Well, I'm happy. You can look for yourself at the preliminary issues. They're listed in the relevant order by SIAC.
They were, my lord. They were. It may be more helpful by way of my submissions to remind the court that the complaint is about the way in which the Court of Appeal dealt with this matter. And when the matter came to the Court of Appeal, the Secretary of State did apply for the Court of Appeal to look at the closed judgment of SIAC. And the court has the order of the Court of Appeal at EF page 287. Could I take the court to that? EF 287. And the Court of Appeal declined the application to look at the closed judgment. And I've dealt with the closed judgment. What is striking, given the complaint that is made by the Secretary of State, that the Court of Appeal should not have proceeded without looking at the closed material, is that the Secretary of State made no application for the Court of Appeal to look at closed material, only at the closed judgment. And if at that stage, where the Court of Appeal is seized of all the issues, the Secretary of State had thought that the Court of Appeal needed to look at the closed material, the Secretary of State could have made an application, but didn't. So this is, in my submission, an academic point at best in relation to the suggestion that the Court of Appeal was somehow inhibited, should have been inhibited from making the judgments it did on the basis of the fact that it didn't see closed material. We are relying on the special advocates who have told the court that there's just more of the same. It's more of the same material. There's no suggestion that it's a different national security case. Indeed, there's no suggestion now by Sir James that the national security case against Miss Begum enclosed is other than you went to Syria, you aligned with ISIL, and you remained there. That's the case against her. And indeed, that was the case that was presented in all of the documents, the reasons that were given for the relevant decisions. So I don't accept that it's now open to Sir James to suggest, indeed he doesn't suggest, that there's a different case. His argument is there's more material, which I say doesn't address the substance of the national security conclusions that the Court of Appeal had reached and the defence of them, which I am advancing. The third point that is made by the Secretary of State by way of criticism of the Court of Appeal is that the Court of Appeal did not have before it the full open ISIL threat statement. That is the generic national security case. And the special advocates address this point in their note, which is at page 4758, which is at paragraph number 10. 4758, open and closed generic material was produced by the Secretary of State before SIAC. There's no indication from it that she presented any increased risk as compared to any other individual in her situation returning to the UK from Syria or Iraq, having travelled there contrary to Foreign Office advice. And the note from the Secretary of State simply doesn't address this point. And of course, if the Secretary of State had thought that this generic open material would assist the Court of Appeal, the Secretary of State could have placed this material before the Court of Appeal and relied on it. It was open material, but she didn't do so. The special advocates set out their conclusion, and I just complete this point before it may be a convenient moment to break. The special advocates set out their conclusion at paragraphs 15 and 16. They're critical of the Secretary of State's complaint. And surprisingly, the court may think the Secretary of State suggests in her note in response, E26 of the separate bundle, paragraph 2, the Secretary of State is critical of the special advocates for addressing these points. I respectfully submit that is very surprising. The lack of transparency inherent in a closed procedure means that the special advocates have a special responsibility to ensure that appeal courts correctly understand the position. And we would respectfully invite the court to not to criticise special advocates for seeking to assist this court in relation to matters that they know about far more because of the nature of closed proceedings. In my submission, they're criticisms of the Secretary of State for suggesting that the Court of Appeal lacked relevant material are well founded. The Secretary of State cannot sustain those criticisms. Would that be a convenient point? I am coming to the end of what I want to submit. Your Lordships, Your Ladyship will be pleased to hear, but I've got a little bit more before Mr. Hickman will turn to Articles 2 and 3. Would that be a convenient moment?
Yes, I think it would, Lord Pennick. Thank you very much. We'll adjourn for 5 minutes. Now, I believe we're ready to resume. Lord Pennick.
Thank you very much, my Lord. Sir James relied on the admissibility decision of the European Court of Human Rights in the K2 case, the same as G1 in domestic proceedings. That, if I could ask the court to turn it up, is at EF 3079. And my friend drew attention to paragraph 60 at 3090. I wish to draw attention to the fact that this was not a case where the applicant was unable to conduct a meaningful appeal. On the contrary, SIAC had decided, and the Court of Appeal had upheld the SIAC conclusion, that he could so have engaged. And we see this in the European Court decision at EF 3084. Paragraph 31, following its conclusion, SIAC proceeded on the basis that there was no good reason why the applicant could not engage in the appeal and fully instruct his lawyers. Although there had been significant communications between him and his solicitors since that date, and he'd made 4 statements, he had not engaged with the national security case against him in any full or direct way. So the case does not assist in relation to what happens if the individual is not able to play any meaningful role in his or her appeal. For the reasons that I gave yesterday and this morning, we do say that Miss Begum is entitled to a meaningful appeal. She will not receive such an appeal. That frustrates the intentions of Parliament. There is either no national security exception, because procedural fairness is not weighed against national security without express statutory provision, or for the reasons I gave this morning, national security can and should be addressed, as the Court of Appeal found, by way of TPIMs, prosecution and other such measures. We say the Court of Appeal was correct to find that the solution to the problem is leave to enter to enable Miss Begum to have a meaningful appeal. And it is not without some interest and importance that this was the solution to this type of problem suggested on behalf of the Secretary of State in earlier cases. One sees this in particular in W2. If the court would please go to W2, which is at EF 2923. This is the Court of Appeal decision, and the court will see at 2929, paragraph 6, paragraph 6, Lord Justice Beatson for the court says that the second question concerns the procedure for determining whether W2 should be able to return to the United Kingdom pending his appeal in SIAC so he can participate in it. That is, whether his return is necessary in order for the appeal to be effective. This question arises because, whereas in proceedings by way of judicial review the court may order interim relief, SIAC is not able to do so. It was submitted on behalf of the Home Secretary that SIAC is able to address the underlying question of whether W2's return to the UK could be facilitated. It could do so in an expedited appeal by him under Section 2 against a refusal by the Home Secretary to grant him leave to remain outside the rules. Should be leave to enter. It was also argued that the issue of whether he could effectively participate in his appeal under Section 2B against the decision to deprive him of British citizenship if he's not in this country could be considered as a preliminary issue in that appeal. It was said, that is by the Home Secretary, that in these ways the evidence and full argument on this matter could be considered by the specialist body designated by Parliament to consider national security cases. So that was the proposal by the Home Secretary, and the Court of Appeal, Lord Justice Beatson, adopted this at 2949 at paragraph 85, where they deal with the matter. They say at 2949 paragraph 85, as Mr. Fordham, he was appearing, as he then was appearing for the claimants, recognised, the question for this court is whether an appeal will be a practical and effective remedy for determining whether an out-of-country appeal against the decision to make the deprivation order would be effective. I do not consider the circumstances of this case are analogous to the scenario considered by Lord Wilson in Chiari. That is because in this case there's no question of W2 seeking first an unenforceable direction, then judicially review that. He'd be pursuing an appeal. If he's successful in that and SIAC considers that his presence in the UK is necessary in order for the appeal to be effective, it will allow the appeal. I'm not relying on the particular circumstances of that case. I draw attention to it simply to indicate that the mechanism of leave to enter was recognised by the Secretary of State as in principle the way to address the problem. I should also address Sir James's suggestion that LTE, leave to enter, would not assist Miss Begum. That point was addressed by the Court of Appeal at EF 283. It's paragraph 121 of Lord Justice Flo's judgment, EF 283, and in paragraph 121, can I invite the court to pick it up in the 5th line, where His Lordship says, as noted above, paragraph 121, line 5, as noted above, Sir James contended that allowing the LTE appeal would not guarantee that Miss Begum would be released from the camp. However, as Mr. Hickman pointed out, the uncontested evidence of Mr. Furner was that if Miss Begum were granted LTE and had access to UFF travel documents, UFF is the EU Uniform Format Form, that's Mr. Ferner, had no reason to believe that she would be unable to return. As he said, the Kurdish authorities have repeatedly made clear in public their determination to facilitate such returns. And that evidence, just to give the court the reference, is EF 500 at paragraph 23. The SIAC judgment suggests a number of other proposed solutions in this case, that is, alternatives to leave to enter. This was SIAC at paragraph 191, which the court does not need to turn up at this stage. 191 EF 364, that's where they deal with it. Can I just comment on them? The first of them, suggested by SIAC, would be for the deprivation appeal to go ahead. And the answer to that was the answer given by the Court of Appeal at paragraphs 112 and 113 at EF 281 and 282. That is, it's unthinkable, their word. It's unthinkable an appeal should go ahead when it will not hear in any meaningful way from Miss Begum. It won't have her account of events, her answers to the Secretary of State's points, mitigation, exoneration that she wishes to put forward. The second possibility suggested by SIAC at paragraph 191, EF 364, was that Ms. Begum could seek a stay of the appeal. And Lord Justice Flo addressed that at paragraph 117 of the judgment of the Court of Appeal. And at paragraph 117, can I just invite the court to look at it, on EF 282, Lord Justice Flo for the Court of Appeal, page 282, paragraph 117, said it seems to his lordship that simply to stay her appeal indefinitely is wrong in principle. It would, in effect, render her appeal against an executive decision to deprive her of her British nationality meaningless for an unlimited period of time. By the time that SIAC gave its judgment, Ms. Begum there'd been 1 year had elapsed since the deprivation decision. We're now, of course, much further on, but that was the context in which SIAC was considering the matter. And of course, when the Court of Appeal heard the case, when it gave judgment in July, we were 16 months further on. There is on the material, in my submission, no end in sight to the respondents, to Ms. Begum's detention, and any stay would be indefinite. In my submission, that frustrates Parliament's intention in conferring on her a right of appeal against a very important decision of the Secretary of State. The third possibility mentioned by SIAC at paragraph 191 would be to allow the appeal to be struck out, but then to apply to reinstate the appeal out of time in the future. And as Lord Justice Flo said, it was paragraph 114 of the Court of Appeal judgment at page 282. Lord Justice Flo said this simply compounds, his word, compounds the unfairness. We also, of course, don't know how SIAC might exercise its discretion in the future to extend time. But the point is it is even worse than a stay. If Miss Begum were not to be given leave to enter, the only other option is that her deprivation appeal should be allowed. And our position, as we've made clear, is that we do not need to contend that the deprivation decision cannot stand, because there is this alternative. And the right to an effective appeal, a meaningful appeal, can be implemented by the grant of leave to enter the United Kingdom. And one would, of course, expect the Secretary of State to prefer LTE as the solution, since that confers no permanent right on Miss Begum to remain in this country, unless, of course, her appeal as to substance were to succeed. So we say, in the absence of LTE, and only in the absence of LTE, the appeal against the deprivation decision should be allowed, because she has a right to a meaningful appeal. She is being denied a meaningful appeal. And in those circumstances, unless a solution is found, LTE being this solution, a deprivation order cannot lawfully continue. Subject to seeking to answer any further questions from the court, those are my submissions on behalf of Ms. Begum on the issue of a meaningful right of appeal. Thank you, my lords, my lady.
Thank you very much, Lord Pennick. There don't appear to be any questions, so we can turn to Mr. Hickman.
Would your lordships give us, and ladyship, just give us a moment to reshuffle
Yes, of course.
our papers? Thank you very much.
My lords, my ladies,
Yes,
I then will be addressing you on the Article 2.3 policy issue. Before I commence my submissions on that, can I just very briefly pick up a point that was raised in questions, which is about the closed evidence that was before SIAC in relation to the LTE appeal and the judicial review in relation to LTE. It's our understanding that there was no additional closed evidence that was adduced in relation to LTE, whether in the LTE appeal that was before SIAC or in relation to the judicial review of the LTE decision. And in the bundle at EF 309 to 310, you'll see an order of SIAC. And that relates to an application under the Justice and Security Act in the judicial review under section for closed material to be adduced, or in principle allowing closed material to be adduced. And the order that SIAC made was that as there was no closed material at that stage, that no order would be made under section 6. But if there was to be any closed material relevant to the LTE issue, then that matter would be revisited. And that's the order made at EF 310, an order of 2nd of October 2019. So there was no additional material adduced on the LTE appeal. And as far as we're aware, the only closed hearing in the proceedings related to the Article 2.3 issue. Turning then to that issue, I propose to make my submissions under 4 headings. First of all, what does the policy or practice of the Secretary of State require? Secondly, what approach would SIAC take if the individual, in this case the respondent, was in the jurisdiction? Thirdly, what evidence was before the Secretary of State and before SIAC, respectively? And fourthly, how did SIAC go wrong, we say, in this case? So taking those in turn, firstly, what did the policy or practice require? I could ask you to look at EF 714, 715. You will see a statement of the policy in a supplemental memorandum by the Home Office that was made in the course of the passage of the Immigration Bill in 2014. And the relevant part begins at paragraph 16 at the bottom of page EF 714. And the very last sentence on that page begins, "It would be unlawful for the UK to breach a person's rights under Article 2 in respect of an individual within its jurisdiction for the purposes of the European Convention on Human Rights. If an individual were not within its jurisdiction for the purposes of the European Convention, then deprivation could not breach the individual's rights. Nevertheless, the Home Secretary has a practice of not depriving individuals of British citizenship where they are not within the UK's jurisdiction for convention purposes, if she is satisfied that doing so would expose those individuals to a real risk of treatment which would constitute a breach of Article 2 or 3 if they were within the UK's jurisdiction and those rights were engaged. The Home Office is therefore satisfied that the new clause is compatible with the Convention right." And my lords, my lady, if you take up EF page 376, this is in the core volume. You will see, and this is in the annex that addresses risks, you will see the way the question is articulated in that document. Not in the core volume. So it's in 376. And paragraph 13, the way the question is expressed before the Secretary of State, the correct question for the purposes of this Article 2.3 assessment is, are there substantial grounds for believing that the removal of British nationality would expose an individual to a risk of mistreatment / loss of life that would not have occurred if he, she had remained a British national? And then it goes on to refer to country information. So that's the policy that was being applied by the Special Cases Unit and by the Secretary of State. Now, in the light of those documents, I suggest, first of all, that there is no lack of clarity about the policy or practice. The approach is precisely the same as the approach that would be taken if the individual was in the UK. The policy simply instructs the Special Cases Unit and the Secretary of State to apply that approach, namely that would be applied if the individual was in the UK in circumstances where the individual is outside the UK. There is no gloss added by the policy to the approach required by Article 2 or 3 of the European Convention on Human Rights. Now, can I just briefly refer you to the case of W2, which considered the policy and which Sir James has referred to. You'll find that at EF 2977 in the Authorities Bundle 4. And first of all, if you look at paragraph 8 of the judgment,
Is this the case called X2, Mr. Begum? Is that the one you mean?
X2. I'm sorry, X2.
No,
I'm sorry. So this is the judgment of SIAC, Mrs. Justice Lang, which considered the approach to take under the policy, and you'll see at the end of paragraph 8 that the approach to take depends on the correct interpretation of the Turing test. That's the real risk test we're all very familiar with. And Government's Counsel did not disagree. Now, the issue in this case was a specific issue, because in this case the individual was abroad, so the policy applied, and in fact they were in Syria in this case. That's where the analogy with the current facts ends, because as you will see from the opening paragraphs, paragraphs 1 and 2, the individual in that case was at large in Syria, and the individual's citizenship had been removed on the basis he had dual British Moroccan nationality, and he contended that he would be at risk of mistreatment in Morocco. But SIAC concluded that because he was at large, the risks that he might face in Morocco were not ones that would be brought about by the deprivation decision, but were risks that would be brought about by him deciding to travel to Morocco. And you'll see that conclusion at the end of paragraph 56. Risks which he may face in any other country to which he may choose to travel are not direct consequences of the deprivation decision. But Miss Giovanetti, who was the Home Secretary's counsel in that case, accepted at paragraph 50 that the position would not have been the same had the individual been in detention in Syria at that time. If the individual had been in detention in Syria at that time, countries to which they might have been removed or transferred, where they might have been subject to mistreatment, were risks that would need to be considered. And you'll see that if you read paragraph 50 and the two practical examples where the Secretary of State's practice would prevent deprivation. The first is where a British citizen is detained in a state which routinely subjects a person to Article 3 ill treatment, but where British citizens are better treated. The second, and this is the relevant exception, is a British citizen who is detained in a second state which, if he were deprived of his nationality, would deport him, rather than to the United Kingdom, to a third state in which he would be at risk of torture. So this case was not glossing the Turing test in any way. It was simply making the point that if an individual was at large, you wouldn't need to consider risks in countries they may choose to travel to, because they would not be direct risk. Now, in the light of those remarks in paragraph 50, the way we've put the case on behalf of the respondent is as follows. We say that the deprivation of citizenship would give rise to a real risk of transfer to Iraq, where there would be a very substantial risk of mistreatment or death, or alternatively transfer to Bangladesh, which after all, it's her connection to Bangladesh that's said to be the justification for the deprivation of her citizenship. Or thirdly, the risk that she would remain in detention in Syria in conditions that do not satisfy Article 3, would not satisfy Article 3 for longer than she might otherwise do, because of the prospect of her being repatriated to the United Kingdom. We relied on those three risks, either taken individually or cumulatively, as satisfying the policy that a person would not be deprived of citizenship if it would expose them to a real risk of treatment contrary to Article 2 or Article 3 if they were in the jurisdiction. So that is the policy and how we say the policy impacted on the case. The second topic is how should SIAC have approached this question, or how would SIAC have approached this question if the individual had been within the jurisdiction, that is applying Article 2 and 3 to an individual who was in the jurisdiction. And in my submission, we get the answer to this question, and all we need from the case of AS and DD, which is in the bundle at EF page 1852. The end of first authorities bundle. This is a Court of Appeal judgment concerning the risks of transfer of an individual or deportation of an individual overseas. And you can see at paragraph 2.
Can I just ask? Can I just ask in relation to this case? Oh, I see. On page 1852, the date's obviously wrong because it's Stratton Clark as a Master of the Rolls and so forth. Would that be 2008? It should be there.
There's hearing dates March 2008.
Yes. So presumably the judgment would be April 2008. Yeah.
Yes.
Okay.
Yes. And my Lord, Lord Sales was involved in the case as counsel for the Secretary of State. The paragraph 2 refers to the fact that there were a number of issues before SIAC, but the appeal before SIAC was allowed on a single ground, namely that there were substantial grounds for believing that the individuals faced a real risk of mistreatment contrary to Article 3 if they were returned to Libya. And then the 4 grounds of appeal advanced by the Secretary of State set out at paragraph 5. First of all, that the evidence of the Foreign and Common Office witness was not given sufficient weight. Secondly, that SIAC failed to direct itself correctly as to the degree of risk. Thirdly, that SIAC lowered the degree of risk. And fourthly, that SIAC's findings did not warrant and were not capable of supporting its conclusion that there were substantial grounds for a real risk. Now, if we move forward in the judgment to paragraph 22, this is at EF 1859, you'll see the heading, the correct test. And first of all, we note that at paragraph 24, there is a quotation from the European Court of Human Rights, and I just read the first line. It is in principle for the applicant to adduce evidence capable of proving that there are substantial grounds for believing that if the measures complained of were to be implemented, he would be exposed to a real risk of being subject to treatment contrary to Article 3. Where such evidence is adduced, it is for the government to dispel any doubts about it. The court continued that to say that a considerable amount of evidence was put before SIAC, which it considered with care, and on the basis of the evidence concluded there would be a real risk. So there was a substantial amount of evidence considered by SIAC in this case. If you turn forward in the judgment to paragraph 41, there we have an expression of the question that SIAC had to answer, and it's put thus: the question for SIAC was whether there were substantial grounds for believing that the respondents would face the risk of torture in the absence of the assurances given by Libya, which had given an MOU. That is a question of fact, and I emphasise this sentence, which it was SIAC's responsibility to resolve. as we've already said, in resolving it, SAIC was obliged to consider what the risks were of Libya failing to comply with the assurances. If that involved a consideration of the hearts and minds of Colonel Gaddafi and members of the regime, so be it. It might be said that such questions are not justiciable. In the words of Lord Hope, their resolution depends on the exercise of a judgment which lies beyond the expertise of the court. That, however, is not the Secretary of State's case, nor could it be in the light of the jurisprudence culminating in Sardi against Italy. And the Sardi judgment had been handed down, I think, in the course of this case being argued. If you go forward in the judgment to paragraph 50, the question what, if any, risks a deportee would face on return is a question of fact for SAIC. In considering that question, SAIC must consider all the relevant evidence, including, of course, the evidence of an expert witness like Mr. Layden. It must have regard to his particular expertise and to the fact that his evidence reflects the view of the FCO, that SAIC is in no way bound to accept every part of his evidence. So it's a very clear expression of the principle that SAIC has to find the fact and is the tribunal designated to consider the risk. And then I'll take you to a few other passages because they are relevant to some of the submissions that Sir James made yesterday. At the bottom of 1868, you'll see the heading, failure to apply the proper test. And you'll see paragraph 54 that initially it had been argued by the Secretary of State that the risks had to be proved on the balance of probabilities, but the judgment in Sardi against Italy had made clear that that would not have been the correct test. The court then considers the judgment in Sardi and Italy and quotes extensively from it, and I'd like to just refer you to a passage at 128, which you'll find on EF page 1871 at the top, under the heading material used to assess the risk of exposure to treatment, contrary to Article 3, and it is stated, in determining whether substantial grounds have been shown for believing there is a real risk of treatment incompatible with Article 3, the court will take as its basis all the material placed before it, or if necessary, material obtained proprio motu. So the tribunal has to consider not only material placed before it, but if necessary, consider material of its own motion.
Hold on, is this, I'm just wondering, is this a quotation from Sardi, in which case the court referred to would be the Strasbourg court?
Yes, that's correct.
Yeah, right, thank you. Which has an investigative arm which can go and carry out inquiries. And for example, the court does send off occasionally expeditions to places in order to carry out inquiries into the facts.
Well, since the European Commission, since the Commission arm of the court was abolished, I think its fact-finding capabilities are much restricted. But anyway, the principle is that the court must consider all the material placed before it. And as I will show you, that wasn't the approach that was taken by SAIC in this case. And then at paragraph 64 of the judgment, and this is directly relevant to a submission that Sir James made yesterday, the court responds to a submission that was made in that case on behalf of the Secretary of State, that the test in Sardi, applying the Suring test, required that the risk should be real and immediate. At paragraph 64, the court rejected that. And yet yesterday, Sir James said, and I quote, that the inquiry as to risk does not require the chasing down of all risks. It requires consideration of immediate risk. that was a position that was advanced and rejected in AS and DD. And then paragraph 66, the Court of Appeal cites again from Sardi. I won't read it all out, but it's making the point that although the assessment of some risk are to a degree speculative, those are the words that it uses, nonetheless, that assessment of risk has to be conducted. And you see that very clearly if you look at paragraph 70 of the judgment, because the court's considering there the hypothetical possibilities that Libya may or may not comply with the assurances that it's given, which of course involved a degree of speculation as to what Libya may or may not do. And yet it's quite clear from what's said in paragraph 70 and the following paragraph that was precisely the exercise that SIAC was required to conduct. And then finally, I'll just point you to paragraph 77, where the court refers to SIAC judgment, where SIAC accepted that there was an element of speculation about how any change of approach might occur, that was inevitable, and the conclusion that is reached after the quoted passage is as follows: we reject Mr. Sells's submission that SIAC there misapplied the test. It correctly said it was for it to assess the degree of risk, causes and impacts of the risk, and said that it was satisfied there were real risks of the contemplated events occurring. That was a correct statement of the test, with the nature of which SIAC was very familiar. So that's the approach that SIAC is required to take, where the individual is within the jurisdiction. And we say that's exactly the approach that SIAC should have adopted in this case. Thirdly, my third head is what was the evidence that was before the Secretary of State and before SIAC. In our written case, paragraph 119, which is at EF 186 to 187 in the core volume, we summarise the evidence that was before SIAC in this case. And the evidence that goes to the three limbs of the risk analysis which we relied on, namely risk of transfer to Iraq, risk of transfer to Bangladesh, and the risk that the respondent would remain longer in detention in Syria than she would otherwise if she remained a British citizen. And let me just pick up a couple of those points. If you look at paragraph 119, subparagraph 4, there is reference to the risks of transfer to Iraq. And we've quoted a French press report dated 10th of February 2019, and I won't read it all out. It actually quoted in one of Mr. Furner's statements, but could I ask you just to read that quotation, please? So that was some of the evidence that related to risks of transfer to Iraq. Other important evidence you will find at EF 1134, and 1135, and you will see in particular 1135 the statement that the UK government has given the clearest indication yet of its preferred destination for British nationals, confirming it's in regular discussion with the government of Iraq about how to achieve justice. And then we also submitted evidence showing the risks of, well, the prospect, the real prospect that the respondent could be repatriated to the United Kingdom. And just to give you an example of that, at page 1126, the same bundle 2B of the appendix, you'll see a report that refers to the pressure being exerted by the United States at that time for countries to repatriate their citizens from Syria. And we've given other references in the bundle in our written case. Bangladesh, there was extensive evidence of risks that the appellant would face of death or mistreatment in Bangladesh were she to have been transferred there. And we've summarised some of that in paragraph 119, subparagraph 5 of the written case. And I won't take you to it. There was also the Bangladeshi Foreign Secretary's statement, which is quoted in our written case at paragraph 31. Now, the evidence that was before the Secretary of State is contained in two annexes of the ministerial submission. And the two annexes are introduced in the body of the ministerial submission, which is at EF 370, that's paragraph 3, little I of the ministerial submission. And very little is said in the body of the submission about the risk. We'll have to look in the annexes to find more. All that's said in the body of the ministerial submission is the conclusion, which is that SCU considers that there are no substantial grounds to believe that a real risk of mistreatment contrary to Article 2 or Article 3 of the ECHR arises as a result of the respondent being deprived of her British citizenship while in Syria. We do not consider that any potential Article 2-3 risks that may arise in countries outside of Syria are foreseeable as a consequence of the deprivation order. And that is all that is said in terms of the facts, in terms of the risks. If, however, you look into the annexes, these do give a rather different picture. So each of the risks that we identified can also be traced through into the annexes. So, for example, the possibility of British citizens being repatriated is dealt with in Annex C. This is at EF 373, that's paragraph 5. At the end of that paragraph, it said, although speculative, it is possible that at some point in the future, British nationals will be treated differently insofar as arrangements may be made to return some individuals to the UK. Paragraph 10 of Annex D, which is 2 pages further on at EF 375, is a little more fulsome in exploring this prospect. And it said at the end of paragraph 10, Annex D, arrangements could be made to lawfully return a detained UK link British or more exceptionally non-British individual to the UK. It is assessed that such arrangements would most probably be exceptional and unlikely to arise in the foreseeable future. That is because solutions are first required to complex problems such as the status of non-state actors, non-British nationals having no right of abode in the UK, and the practicalities of any transfer. Well, obviously, at least the second of those has no application to the respondent. And then just to complete this, if you look at paragraph 27 of the same annex at EF 378, it is again recognised that it's possibility that in some point in the future, British nationals will be treated differently insofar as arrangements may be made with these groups to return some of the individuals to the UK. We do not consider this distinction would create for those who remain a serious risk of treatment falling below standards required of a detaining party by international humanitarian law in non-international armed conflict, or which would constitute cruel, inhumane, degrading treatment. However, that conclusion was not accepted by SIAC, in that we know that SIAC accepted that conditions in the camp were Article 3 non-compliant in Al Roj, and it was prepared to accept and proceed on the basis that the same was true for the camp which the respondent was in for a short period before she was moved to Al Roj. So that's the prospect of return. In terms of risks of transfer to Iraq, that's mentioned in Annex D at paragraph 15 at EF 376 under the heading Iraq. And although the prospect of transfer to Iraq is not contemplated or even addressed, it is quite clear from paragraphs 15 and paragraph 16 that were an individual to be transferred to Iraq, the risks of mistreatment or death would be very significant indeed. Bangladesh is considered at Annex C, paragraph 6 to 7 at EF 373. And paragraph 7 in particular, consistent with the evidence that was adduced by the respondent, open source reporting indicates there is a risk that individuals could be subject to conditions which would not comply with the ECHR in Bangladesh. There is some reader reporting to suggest that Bangladesh authorities may have carried out extrajudicial killings of detainees and other enemies of the state. So that was the evidence that was before the Secretary of State. The evidence in relation to Bangladesh and Iraq was therefore that were there a prospect of the respondent being transferred there, there would undoubtedly be significant risks to her in those countries. But that risk was discounted on the basis that it was said to be unforeseeable, that is, the risk of transfer. Now, before SIAC, no witness statement or evidence was filed on behalf of the Secretary of State in support of the assessments which I've just taken you to. Evidence was filed, as I've shown you, by the respondent, and a witness statement was also filed, but the Secretary of State did not have any questions for that witness. So before SIAC, the position was that there was evidence by the respondent, but it took the form of conclusionary assessment. We don't know what the basis for the risk assessments that I've just taken you to were, which individuals made them, and there were no individuals that were tendered for questioning on those assessments. So that was the evidential picture before SIAC. Turning then to the last topic, how did SIAC go wrong? SIAC decided this issue in 2 paragraphs of its judgment, and you'll find these at EF 346 of the bundle. paragraphs 138 and 139 of SIAC's judgment. And first of all, SIAC begins at paragraph 138, end of that paragraph, by making clear that it is not deciding this question on the merit, but rather is applying the question applying the principles of judicial review. In the next paragraph, in the middle of paragraph 139, SIAC says that the Secretary of State was reasonably entitled to decide that the deprivation would not breach the policy. There is the application of a principle of reasonableness akin to a public law standard. SIAC also concludes in the same paragraph, on the basis of the very short conclusionary statements and assertions that I've shown you, that the Secretary of State was not required to speculate about the chances of removal to Bangladesh or Iraq. Now, we say that that was the wrong approach for SIAC to take. The fundamental problem with the approach that SIAC adopted was that it did not itself attempt to find any fact or assess whether there was a real risk at the time the deprivation order was made that the consequences would give rise to a real risk of treatment contrary to Article 2 or Article 3. Now, within this overall objection, there are three specific errors. Firstly, SIAC failed to consider the evidence adduced on behalf of the respondent and based its conclusions on the basis of the material that was before the Secretary of State, which is the conclusionary assessments in the annexes. Secondly, that it did not take into account the fact that there was no opportunity to challenge the Secretary of State evidence. And thirdly, that SIAC didn't take into account the need to assess the real risk that could arise, even if there are uncertainties and even if this involves a degree of speculation. In each of those respects, in my submission, SIAC's approach contrasts markedly with the approach that is articulated in the AS case, which I have taken you through in some detail. We say SIAC should have adopted that approach. Firstly, this was a merits appeal. SIAC should have asked itself whether or not the deprivation of the respondent's citizenship breached the Secretary of State's policy. Secondly, we say even if SIAC was entitled to take a judicial review approach, it took the wrong approach because there is authority that the court would itself need to decide, even in a judicial review, whether or not there was a real risk, and that's the case of Evans. Now, the Secretary of State, in her submissions at paragraph 67C, won't ask you to turn up, relies on the judgment of Mr. Justice Irwin in the case of Y1. And that's in Authorities Bundle 4 at 3EF 3047. And if you turn to page 3050, you will see there's a heading, the Commission's approach. And these, in fact, are some of the passages in this judgment which Lord Panic referred you to this morning in relation to the Remon issue. And although SIAC is here considering the national security case, it is considering explicitly what it should do about material that was not before the Secretary of State, but sheds light on the risk that were present, or the facts as they were at the time the deprivation decision was taken. And the conclusion that SIAC comes to is that it must consider all of the material, even material that wasn't before the Secretary of State, and even material that was generated after the decision to deprive the person of citizenship. However, SIAC had to be careful not to place weight on subsequent events. So subsequent material which evidenced risks that were present, the date the decision was taken was legitimate, but changes in circumstances not legitimate. And you'll see, for example, from paragraph 17, the conclusion that's reached. We've considered the matter carefully. We agree with the refined position adopted by Mr. Swift, as he then was. It is legitimate to bear in mind material which elucidates the facts before the decision to deprive, including the state of mind of the appellant, even where that material only becomes available after the decision and could not have been considered by the Secretary of State. It may be correct to consider that events after the decision, only so far as they elucidate the facts up to and including the date the decision was taken. Obviously, this is concerning the national security case, but the same central principle applies to the real risk analysis, which has to assess the risks at the date the deprivation decision was taken. And this is an authority that is relied on by the Secretary of State as supporting the Secretary of State's submission that SIAC should adopt some form of judicial review approach where it doesn't consider material unless the material was in front of the Secretary of State, and that its task is limited to deciding whether the Secretary of State's assessment of that material was reasonable. In my submission, this authority simply doesn't support that proposition at all. And indeed, it supports the case that we have advanced. My lords, my lady, I've seen the time. I have probably another 10 minutes of submissions to make on this point. So maybe a convenient time to stop, pause.
Does that mean you have about 10 minutes before you complete your submission?
That's correct.
Yes. Well, it's slightly early. If we can adjourn just now, but shall we resume in that case at 1:55?